Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. So many friends have asked me to give a lecture about the power of the police in seizing the vehicles which were caught or when the persons were arrested under section 185, that is drunk and drive cases, 185 of the MVAct. Simply to say, recently it has come in the press that Justice K. Lakshman of Honorable High Court of Telangana, he has clearly given directions, or he has clearly stated that the police have no power to seize the vehicles under section 185 MVAct. Right? So normally we get emboldened. No, police have no authority to seize any vehicle like that. So what is the real background? What is the real story? Can you compel the police officer to release your vehicle immediately or not? This is the question, basic question. So normally we'll be feeling happy, definitely police, on knowing that police cannot seize the vehicle. Now let us go into the details. So a lot of writ petitions they have been filed in the Honorable High Court of Telangana. One such, WP number 1647 by 2021. So they have questioned the propriety of the police or the power of the police to seize the vehicles from the driver or from the occupier or the rider who is in intoxicated stage. So as you know very well, as youngsters, most of them may be knowing, whenever you come out of a bar and restaurant and after coming to a distance of about 100 feet or so, definitely, particularly on Saturdays and Sundays, you will be intercepted by the police on duty, and they will keep the breath analyzer with you and ask you to inhale. So if the percentage of alcohol in your body exceeds 30 milligrams out of 100, 30 by 100, that is our count. So exceeds, then the case will be booked against you. Here this. Now, if there is another person to the vehicle, suppose if you are going in a car, so if there is another person who is not intoxicated, then as per section 207 and 202 also of the MVAct, definitely 207 says yes, they have to give the vehicle to the person who is not intoxicated. This is the direction the court has given. Right? Mind you, please remember, if you are, that's why even ads also you might have seen, please don't drink and drive. Keep a person who is not drunk for safe side or for driving, for example. So if the other person is not in a drunken stage, definitely the police, they have to hand over the vehicle to him. Number one. Number two, if the vehicle, if owner or rider is found in intoxicated stage, so now the constitution comes, the power of arrest, section 56 also, then they have to, according to D.K. Basu versus State of West Bengal 1996, they have to, the police have to inform their nearest relative, or they will make him to inform the nearest relative to come and take the vehicle. He will go to court. Of course, they have to release him on bail. Of course, 41 years CRPC gives the utmost leverage to the people. Even 7 years below, they have to give in bail. So that is the second condition. So they have to inform the nearest relative. Then third one, if nobody is available, this fellow is on drunken stage, there is no other person, then the vehicle is to be kept near the nearest police station, and after the person, owner produces the C-book, then it has to be released. So here, once again remember, the police do not have any power to seize the vehicles except under 207, the MVAct. So on the production of the RC, certificate registration, definitely they have to release the vehicle. Right. Of course, if the police wants, here remember, if the vehicle belongs to some other person, then the police can file the charge sheet against the driver as well as the owner also. That should be done within 3 days. So please remember, magistrate under section 4, under rule I think, 448A, yes, he has to take the case on file and within 3 days he has to dispose the same if it is against the driver and owner, right? So then the vehicle has been brought, it has kept, nobody claims for it. Yeah, so what is the symbol or symptomatic example of a police station is, lot of vehicles will be kept outside the police station. It will be in rusty condition. So if nobody claims, then police can take action as per law, as per CRPC. They can get them auctioned. So these are the directions given to the police. If the police do not follow the so-called directions given by in this WP by the judge, then they are liable for the Contempt of the Court Act if they do not follow. Now, coming to the reality, what happens? Suppose if a person on a motorcycle is found in a drunk and drive, what do the police have to do? Are they not supposed to keep the vehicle aside? Can they allow him to drive the vehicle? No doubt, they do not have any power to seize the vehicle. So this also the court kept in mind. That's why they said you have to inform the nearest relative, right? So here I want to tell you, police can impound the document under section 206 of the MVAct. They can impound the document and actually they can seize the vehicle. So in pursuance of section 207, normally they can impound the document under section 206, that is suppose in a drunken stage, 185, yes, drunk and drive, section 185, 190, then 194 ABCD, latest amendments are also, for all these cases, yes, they can impound the vehicle, they can impound the documents particularly. They can seize the vehicle, 207, it says without C-book. If there is no C-book, definitely the vehicle can be seized. If there is C-book, they can impound the C-book and ask him to come on some other day. So please remember, so these are the directions given by the Honorable High Court of Telangana. So as a precautionary measure, I want to inform all of you, please don't drink and drive. So if you are so much addicted to drinking, keep a person by your side, let him drive the vehicle. When he is not in a drunken stage, the police cannot arrest him. So please get ready with the vehicles of the record. If the C-book is there, they will take the C-book and release the vehicle. But practically, how far it is possible, everybody will have personal experience and it is up to you as to what to take the inference, right? Anyway, these are the directions given by the Honorable High Court of Telangana. So these points please remember and inform your friends also. Thank you very much.